You ready? Okay, where we left off, and no, I'm not going to start from the beginning. Don't worry. I'm not cool. Where we left off, we talked about the chronology of Dr. Singhania's theory, how, as Mr. Barnett put it, it evolved over time. How ironically, and not coincidentally, it seemed to evolve to try to help the prosecution case. She said at the preliminary hearing, she testified this in this courtroom too. She acknowledged what she had testified to previously, that she didn't care about the hospital records, didn't help her in her autopsy. The medical records didn't help in determining cause of death, really. And again, the one piece of physical evidence she felt showed her, demonstrated what the cause of death was that one bruise on the side, right here. That's it. All of this after her autopsy. But after the preliminary hearing, after she testified to everything we just spoken about, which was not good for their case, because that one discrete event, which would come at the end, which both of them were off of him at that point, can't help their case, not for a murder case, involuntary manslaughter, not for anything. So after the prelim, she testified here. She met with the prosecutor again. And then the theory changed. Isn't that a coincidence? So she testifies at the preliminary hearing. It's a discrete event, a one-time event. Here's the evidence of that one-time event. And it happens at the end, when his voice starts being more elongated, which they're off of him at that point. But then she has a meeting with the prosecutor. And now she has a different theory. It's no longer a discrete event, because that won't convict anybody. It's prolonged compression now, which is the opposite to what she testified to under oath back in May of 2012. The opposite. One-time event, one discrete event, at this point in time, here's the evidence of it. That's not the same as prolonged compression. And now she says that even restraining the legs would affect respiration. She didn't say it back then. Specifically, this was her evidence. This is not the legs. I mean, you don't have to be doctors to know this, folks. This is the upper torso. But now she says, this doesn't mean anything now, because both those gentlemen are at the legs. So now she has to have a different theory. So now it's prolonged compression, so now it can happen over time to try to bring everybody on that one umbrella. And now it's the legs too, because this won't cut it. But since they're both at his legs, there we go. She even went so far to say, and this is where it gets into another world. I mean, let's be honest. Putting pressure on the shoulder, even with 2 fingers at that point in time, would affect respiration. Come on. That's not a medical analysis. That's a conclusion to help their case. That's somebody testifying to what could be a contributory factor, not to what would affect respiration or compression. Because she can't get there any other way. Because she has to bring in everybody into the picture to say it all contributed somehow, because we can't get to causation if she doesn't. And it's ridiculous. It's preposterous. But that was her testimony. And that train wreck, and that's what it is, that train wreck ended up initiating or drove the prosecution to bring on Dr. Hugelin to clean it up. So after the prelim, which her theory wouldn't convict anyone, after her meeting with the prosecutor, anything would affect respiration. Even 2 fingers on Kelly Thomas's shoulder would affect respiration. That was the myth that they're trying to sell you in this case of compression. Now, using an analogy, if this was any other situation, not even the burden of proof beyond reasonable doubt, which that doesn't even come close, that's not even in the ballpark, any other situation where somebody changes their story to you just to try to convince you of something, you'd never buy it. You know, we have the cliche used car salesman. That wouldn't even sell a used car. But now we have 2 men's lives on the line here. She couldn't recall if the video had audio the first time. So how would the audio help her? She couldn't recall if I had it the second time, so how would the audio help her? Dr. Leckwood seemed to harp on the audio. Well, if he says he can't breathe, he must be in respiratory distress, which doesn't make a lot of sense either, because who knows if he's being honest? Who knows if it's really true? But that didn't even matter to her. She also didn't have any idea, none of them did, how much air, just in measurement. What's the average amount of air, or how much air would a person need just to be able to breathe and stay alive? You're making this conclusion. You hear in a murder trial, testifying for the prosecution, trying to convict 2 police officers, and you're saying, basically suffocate him to death by holding his legs down. How much air would a person need to breathe not to be suffocated? I don't know. I really can't calculate that. Well, then how can that theory come close to meeting the burden of proof if you can't calculate that? What's the response? I'm not an expert in that field. That's not my expertise. That's proof beyond a reasonable doubt. That's the evidence they put on to try to prove this case. The bottom line, when you call them on the carpet, when you ask them some tough questions finally, I'm not an expert in that field. That's not my expertise. But you've got the audacity to sit in that chair under oath and give us your opinion about how a person died. And then when we ask you to be detailed about that opinion, we scrutinize that opinion, well, gee, I'm not an expert, I can't answer that. And that's not the first person who said things to that effect for the prosecution. Again, we're talking about the myth of this compression theory. Dr. Leckwood. Now, he's a chief trauma surgeon. And look, surgeon at UCI Medical Center, trauma surgeon. He gets people, when they're in trauma. He's a trauma surgeon. They go into ICU when he gets them. He's not dealing with people who can complain of things. They're already in a really bad position in the first place. He treated Kelly Thomas on those dates between July 5th when the event occurred and July 10th. And his testimony, if you look at it, what they're basing some of their case on, what they're basing their theory on, the only thing they can actually try to argue to you when it comes to the evidence, his testimony was full of ifs, cans, and mays. Is that proof beyond reasonable doubt? If this happens, this can happen, it may happen. See, they have a burden. When you put yourself in the world of what may happen, or what can happen, or if this could happen, those are the kind of words that defense attorneys get accused of using all the time. But they've got a burden. They can't use the word if. If isn't proof beyond a reasonable doubt. If doesn't get you here. Doesn't get you there. Can doesn't get you there. By the way, I'm trying not to hit anyone in the face with the laser, so that's why I'm a little bit off on that. And neither does may. Here it says you may rely on circumstantial evidence, but look down here. If there's more than one of those interpretations, they're all ducking. If you can draw 2 or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and to guilt, you must. That's how the law talks. You can lift your heads up now. That's how the law talks. See, when you have a burden of proof like the prosecution, you can't talk in terms of if or may or can. It has to be it did. That's it. For a causation, it did. For a substantial factor, it did. Not that it could, it may, it can. Thank you, Deputy. So he said low blood pressure can be from. Can be. They're trying to throw everything but the kitchen sink in here, somehow to have my client's 2 strikes to Kelly Thomas's face in self-defense, somehow to be a causation of death, somehow to be a substantial factor. He says low blood pressure can come from bleeding, because he had low blood pressure going into UCI. It can come from lung collapse. It can come from shock from the heart not working. Well, that sounds like, wow, one of those 3 things can cause that. But what were the facts of the case? What was the actual evidence in the case? The actual evidence in the case, let's go to bleeding. We heard a lot about bleeding. We saw bloody pictures. Let's look at paramedic Zilgit. He estimated only 100 to 150 cc's of blood loss. Now, for most of us who we're not medical professionals, what does that really mean? It was not significant. That's somebody, when they call the paramedics, they're there to deal with trauma. They're the first responders. He said, when he testified, He's been on scenes where people bled a lot more than that, and he wasn't worried about that either. And this was much less. Now, it looks like a lot to us as lay people because it spreads itself out. But what's the actual amount, both on a medical, clinical level and in reality? He's not worried about the person bleeding out because it wasn't close to enough. Not worried about low blood pressure because it wasn't close to enough loss of blood. Dr. Vilk, again, with credentials bar none. No significant loss of blood. But he backs it up with the medical records. He described what HCT means, hematocrit. He said that's basically your red blood cell count. And that's what they gauge how much blood you need to have. If too much blood loss, not enough blood loss. And he went through those medical records with you. He wasn't just throwing out an opinion. He backed it up with the facts. And he said, look at those medical records. He came into UCI with a 37.6 HCT. That's within the normal range. So maybe he lost some blood, but he's still in the normal range. And he said 100 to 150 cc's of blood volume is less than when a person actually donates blood, which is 500 cc's. So you can do the comparison. These are the actual facts. Is the blood loss a significant factor of anything when that's how much is estimated? He's in the normal range of how much red blood cells he needs. And that compared to that, I mean, you go to the Red Cross, you go to your local school they have the van set up, you strap your arm up, they take out 500 cc's. Is the person going to die? No, they have a few jelly beans when they're done. That's the reality. That's not theory. It's not conjecture. It's not if, can, may. That's reality. That's the evidence you saw in this case. That's what the case is about, ladies and gentlemen. It's about the evidence. It's about their burden of proof. It's about that. See? If you can draw two or more reasonable conclusions, well, in this case, there's only one reasonable conclusion. It's not significant. It wasn't a factor. It may look bad to most of us because we don't deal in this. A doctor can look at things and it means nothing to them because they're looking at it from a clinical perspective. The pictures to affect us, to a doctor, that's what they look at every day. But here's the reality of what it really means. Or lung collapse can come from blood loss, right? But was any lung collapse in this case? No. Or shock from the heart not working. That's what could lead to low blood pressure. Shock from the heart not working. Now here we go. Was there evidence maybe of the heart not working properly? Cardiomyopathy. Dr. Karch testified. Now this is Dr. Lekowitz speaking. He's saying the low blood pressure they found upon arrival at UCI. Now he's been through St. Jude. He's been intubated. All right. Now he's got help breathing. He has a pulse. He's had an IV put in already. He's been to another hospital. He's been stabilized as much as they could, get them to a trauma center. Now he's at the trauma center. He still has low blood pressure. Why? They got the heart beating again. He's got oxygen going through. And Dr. Vilk testified that those levels were pretty much normal going into UCI, the oxygen, the carbon dioxide. His body should be fine, but he still has very low blood pressure. Why? The third reason Dr. Lekowitz gave is shock from the heart not working. Cardiomyopathy, heart disease, cardiac arrest from overexertion. Does that make any sense? Yeah. Is that also something that's based on the evidence? Yes. Is that also up here one of the two or more reasonable interpretations or conclusions from the evidence? Yes. The myth of the nasal fracture obstructing the airway. Again, the myth. Black ink. Dr. Lekowitz testifies when he's asked by the prosecutor. Look at what he says. The face has a very good blood supply. If you fracture the bones, they'll obviously bleed. If they bleed into a cavity, that may be contained. But if they bleed freely into the mouth or into the airway, so the nasal fractures can actually then lacerate the skin, and the blood can come out through the inside of the nose. Does he ever use the word did at all? Now, the prosecution may stand up and say, that's just semantics. No, it's not semantics in a case where they have a burden of proof, because did mean it actually happened. Can means it's in the realm of what could happen, what may happen. Can means theory. Can means, yeah, there are times when that happens and there are times when it doesn't. For them to prove their case, that has to say it did happen. That's causation. That's that link. And they use those words specifically because that way they don't have to get there. And then the nose is connected to the back of the throat. That's why we breathe through our nose. It goes down to our lungs. For the same reason you breathe air through your nose, it goes into your lungs. If you have a lot of blood in your nose, if you breathe in on that, the blood will go down your trachea. If. But what actually happened in the case? If you're not awake to protect it, or to put your head into the right position, or if you're not able to get the blood to not go down the throat, and you're just gasping for air, it's going to just go into your lungs. Now, the prosecution may try to harp on this. You're not awake to protect it. But what was the position Kelly Thomas was in waiting for paramedics? When he was still talking, he was positioned on his side, specifically. Now, he's on his side, and anything that's going to come is going to come out this way. And that's why you've got the blood on the street. Because first he was on his face. They had to handcuff him in the front. They rolled him to the side and handcuffed him. So any blood that's coming out is going to go downward. It's gravity, number one. Number two, on the side, the same thing. And when the paramedics showed up, if the blood was so bad that he was gasping or gurgling or was getting blocked in the airway, don't they do something about it? Don't they suction it? Don't just wipe his face. Because according to Dr. Lekua, we'll go back a slide, if we can. He says, when you breathe in, if they bleed freely into the mouth or in the airway, so the nasal fractures can actually then lacerate the skin and can come out through the inside of the nose. If you have a lot of blood in your nose, if you breathe in on that, the blood will go down your trachea. So if that had happened in this case, they would have done something about it. They were there, the paramedics. But you heard the testimony. It wasn't gurgling, it wasn't gasping. What they did was wipe away what kind of blood? Paramedic Zilka was very specific. Coagulated blood. He had a big beard. The blood was coagulated in his beard around his airway. They wiped it off. That's all they did. Didn't have to suction, didn't have to try to get anything else out of there. That's the actual evidence. So all the ifs and cans of that statement didn't actually happen. That's called a burden of proof that they haven't met. And again, if he was not breathing well enough to sustain life, they would have intervened. And they're right there. You've got somebody at his head, because they're going to put a C-spine protection on him. Somebody on this side, somebody on this side, somebody at his feet. They're all looking at the same person. If he's not breathing, or if he's not breathing well enough to be alive, they're not going to put a mask on him. And you heard Captain Stanchik, and you hear on the tape, they say more than once, get the bag ready. For 6 minutes? That he's not breathing for 6 minutes. At some point, is it get the bag ready or put it on him? Because he was breathing. And he was breathing well enough to require no intervention, which means no compression occurred. And on top of that, we both know that the position of both the officers, they weren't even there to compress him at all. But more than that, the lungs were checked after the ET tube was placed at St. Jude, and they were clear. Now, had the blood gone down there before he got to St. Jude even, so if he was really aspirating blood at the scene, the if cans or mays that they're trying to rely on, his lungs wouldn't be clear without suction. And they were. We just spoke about this. No obstruction in the airway. He testified to this. No blood in the airway. No obstruction. No gasping. No suction. Dr. Vilk, that's what he relies on. No significant amount of fluid in the lungs from the chest, X-ray. And Dr. Budoff, her last witness, confirmed the same thing. No record of blood or fluid in the tube. No evidence on the video of obstructed airway or respiratory distress. And that's from an expert who that's what he deals with, is respiratory distress. He was also the only honest one up here as far as the ventilation experts are concerned between Dr. Hugelin, Dr. Singhania, Dr. Lekwa, and Dr. Vilk, because he said very honestly, look, I can tell you what it wasn't, but I can't tell you what it was. That's an honest answer. When he was pressed, he said, look, It wasn't compression. It's simply the mechanics, the studies, my experience. It was not, period. There wasn't any question. So do you know what killed it? I can't tell you what it was, but I can tell you what it wasn't. The problem is, for the prosecution, they have to tell you what it was. That's a problem. Now, Dr. Leckwell also admitted there were no anatomical injuries alone that would have caused or accounted for the death. That means the facial strikes, they're anatomical injuries. They don't cause death. De Wilk said the same thing. Broken noses don't cause death. Broken cheekbones don't cause death. All the injuries described, either individually or collectively, would not have accounted for Kelly Thomas's death. That's Dr. Leckwell speaking. That's the testimony. That's the evidence. Everything put together doesn't account for the death, which is a big problem for them. So we have to have this other theory, and we have to rope in anybody involved in it, hopefully, because if we have a big enough net, then those two fish come in too. But he also had to admit that the aspiration in the lungs could have come from resuscitation. So even the little bit of aspiration doesn't show up on an X-ray that they want to depend on to show somehow the facial strikes had some kind of causation. That aspiration could come from resuscitation. And he was resuscitated in the ambulance, failed attempts, and at St. Jude. And that's what it normally can come from. Again, back to here. 2 or more reasonable conclusions. You must accept the one that points to innocence. That's the law. That's the instruction they don't want to show you. That's the law. And this is one of the focal points. No pun intended what's on the screen. No focal consolidation means that on these chest X-ray, they were not able to see a collection of fluid within the lungs big enough to show up on the X-ray. Insignificant. Not a contributory factor. Not a causation. Not anything. Not guilty. Now, Dr. Leckwell also had to admit that in assessing whether mechanical compression actually would cause hypoxia, but actually inhibit breathing to an extent where the person's oxygen supply will get so low that they could become hypoxic and then have irreversible damage. You have to be able to calculate the duration of the compression. How long was it? Doesn't it matter? And he said everybody could be different. It's variable. Location of the compression. Where was it on the body? He said it makes a difference. Do the legs make sense? Constant versus intermittent. Wouldn't that make a difference too? Constant pressure for a long time. That's Dr. Hugelin's theory. That's Dr. Singhania's second or third theory, right? Or intermittent. And Dr. Leckwell said it was intermittent. We'll get to how that plays in a minute. The amount of weight, how much weight was it? Was it one constant amount of weight the whole time? Did it vary? Did it shift? Dr. Leckwell, when asked about, all right, we agreed those are factors to consider away. How'd you factor those in? Oh, I don't know. He couldn't give an opinion about any of those factors, how they weigh into this case. He didn't calculate it. He didn't consider. He said his answer was, well, this is multifactorial. It's too many variables. Well, does an answer like that, too many variables, is that proof beyond a reasonable doubt? Is that meeting a burden of proof? This is your theory, doctor? This is what you're saying happened? So we're asking how you get there? I don't know. There's too many variables. Is that proof beyond a reasonable doubt? And his theory was intermittent compression over time. And he was very specific about that. Because we went through the video with him, and the first 2 out of 3 times he said there was compression, you couldn't see anybody on the screen. They were behind the tree. And his response was, well, I can hear him say it. No, I'm asking if you heard him say, I can't breathe. Where is the compression? Well, he was in this position a few moments ago, so I'm assuming he'd be over there, the police officer. You can't assume that. This is called a court of law. This is called a burden of proof. You know where he was? No. You know if he was compressing anything? No. No. But it was intermittent over time. Well, there's a problem with that. From this point on, you testified there is some form of ongoing compression from this point on. Is that correct? And it may be intermittent at times. Again, the word may. And it changes as time goes on. But he can't calculate what the changes mean. He can't calculate or tell you how they've way into the entire equation. That's called an excuse. Anyone who's raised kids, you call your kid on the carpet about something, and the first answer is, well, Tommy had it. Well, I called Tommy's parents, and Tommy doesn't have it. Well, I left it at Sally's. Well, I called Sally's parents too. Well, maybe I left it in the backyard and it got blown away by the wind. That's what that is. You know it when you see it in real life. You would accept it from your kid. You can accept it from a doctor on a witness stand in a murder case when they have a burden of proof. But here's the problem, folks. He says it's intermittent. It may change over time. But it's not what Dr. Singhania said. All right. Her first theory was it was a single discrete event, not intermittent compressions, one. Her second theory says it's prolonged over time, not intermittent, one long compression. So now we have three theories so far. Three. And I call them theories because they haven't been proof of anything. But it gets better. Dr. Hugelin says, not only does he say it was compression that was prolonged over time, he specifically testified, no, it was not a single discrete event, so he objects to Dr. Singhania's first theory. But more than that, he says it was not intermittent. So Dr. Hugelin also objects to Dr. Lekowit's theory. So you've got three purported experts by the prosecution to prove causation, to prove this compression theory is the cause of death, and they can't agree. Between three, they got four theories. It was a joke. Have three lawyers have four opinions. These are three experts. They've got four theories. Is that proof beyond a reasonable doubt? Is that really proof beyond a reasonable doubt? Let's go a step further, because we're not quite there yet. But in the negligence arena, we get to criminal negligence. If criminal negligence is something that an ordinary person using prudent care is supposed to be able to know that that's going to be the result, and may still be causation as well. If their experts can't agree on a theory, how are these guys supposed to know? In the heat of the battle, within a few seconds of a decision, consistent with their training, that somehow that training was so far off that it was going to lead to death or to great bodily injury, when they can't even agree? And that's their field? Three prosecution doctors, three prosecution theories. Actually, it's four, if you count Singhania's first theory. Compression, single discrete event, that didn't work. So, intermittent compression from Dr. Lekowit. Gee, in case that doesn't work, Dr. Hugelin with prolonged compression, and now his subordinate will agree with that because she's been met by the prosecutor. Now look at causation. We've been through all this. The act, which would be either the facial strikes or the compression, that causes death, is the direct and natural and probable consequence of the act. Okay? Direct, natural, and probable consequence, which means foreseeable. Now, we've been through the facial strikes. The bleeding was not significant at all. It doesn't look nice on a photograph, but it wasn't significant. Didn't cause aspiration. Didn't cause any blockage of the airway. Didn't cause low blood pressure or bleeding out. None of those things. Now, these pictures aren't pleasant to look at, but you've seen the bloody picture often, and it's not easy to look at. But that's cleaned up a little bit. Leave the backlight on that. I'll leave it. That's from the autopsy, but that's cleaned up a little bit. And in that picture, backlight. The backlight, I think, for this one. As much as it's not pleasant to look at, that's not the same thing as all the blood. Why? Because now he's been cleaned up a little bit, a lot. You see the stitches, he got stitches. He had lacerations. Well, you also see in that picture, the expert. That'll work, yeah. Thanks. Yeah, he's got some bruises, he's got some cuts. He's going to have bleeding in the face because he did get cut up a bit. He's got stitches. Now, where they all came from my client, where they came from the punches of Officer Wolf, where they came from just being rolled around the street, we don't know. That hasn't been proven up. But something came from my client. We're admitting to that. But it wasn't a cause of death. The bleeding was not a direct, natural, and probable consequence. It didn't lead to cause of death as a natural, direct, and probable consequence. It had no connection from all of the evidence, from all of the doctors, whether they like to say it or not. And the compression is the same thing, especially on the legs. So here we are, just on the compression theory, just on the facial strikes theory. You haven't gotten past causation yet. Not by proof beyond a reasonable doubt. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. And come on, compression on the legs causes death, contributes, is part of that causation. That it'd be a direct, natural, and probable consequence of compression on the legs to death. That's reasonable. So question, folks. How can the prosecution claim to have met their burden of proving beyond a reasonable doubt that Kelly Thomas's death was a direct, natural, and probable consequence of mechanical compression of his chest, when the prosecution experts can't even agree on how and when that compression occurred? That's the answer to that question. How can the prosecution claim to have met their burden of proving beyond a reasonable doubt that Kelly Thomas's death was a direct, natural, and probable consequence of mechanical compression of the chest, when their own experts admit there are multiple factors to consider in forming an opinion that compression causes hypoxia, and they couldn't offer any information regarding any of those factors in this case, in this situation? And you know what? Dr. Lecker was asked a question, and he kept trying to hide from the question. And he was asked, all right, somebody Kelly Thomas's size, his size and weight. You know what his size and weight were, doctor? You had him in the hospital. Somebody his size, how much air would he have to breathe? How long would the compressions have to be on him? Where would they have to be? Those factors you just talked about, doctor, how would they affect somebody Kelly Thomas's size to cause hypoxia? And his response was, I can't answer that. That's multifactorial. There are too many variables. No, there aren't variables. His size, not the whole population, Kelly Thomas. He's 37 years old. You want to say he weighs between 170 and 200 pounds? Let's say 150. Say 110 pounds soaking wet. Whatever size you think he was in the hospital, his size, his weight, his age. I can't answer that. They have to answer that. But they can't. Another problem. So they try not to answer it. That's the black ink. How can the prosecution claim to have met the burden of proving beyond a reasonable doubt that Kelly Thomas's death was a direct, natural, and probable consequence of the facial fractures, when the actual evidence is directly the opposite? And it is the opposite. We've just gone through it. That was another gimme. They can't. So if the doctors can't agree on mechanics of compression, and the doctors don't have any information how the mechanics of compression worked in this particular case with those factors they talked about, and the evidence clearly shows that the facial fractures did not and would not contribute to Kelly Thomas's death, then a reasonable person would not know that death would be foreseeable or likely to happen from that act or any other. And the same questions, folks, they can't agree. They can't speak to the mechanics, the actual details on mechanics, facial fractures. Then the prosecution also did not prove that any of my client's acts were a substantial factor in causing the death. The other part of causation. They haven't come close. But it's more than that. See, we just went through the prosecution case. That was their evidence. And just by their case alone, before we even got to Dr. Vilk, they haven't come close to proving causation. Just from their own evidence. But it got worse for them. And we've gone over Dr. Vilk, and it's been spoken about by Mr. Barnett. And just a reminder, I'll go through a little bit more quickly. He's seen false claims of respiratory distress before in the jail. He's seen the actions happen. He knows how to assess it. He's got the credentials for this particular case. He's just one county south. He did the studies. He did the studies. And with each study, they added more information to get more information. So it wasn't like, oh, well, you did the studies on positional asphyxia, but this case was about mechanical compression. Well, gee, we did that too. And we did it safely. So once we saw that the positional asphyxia wouldn't cause death, we added 50 pounds. When 50 pounds was okay, we added 200 up to 225 pounds. Little by little, more and more information. He had the studies with people being tased, with people being pepper sprayed. He wanted to see how ventilation works in every different situation. And he says very specifically that this asphyxiation, suffocation, the mechanical compression that causes hypoxia does not occur with intermittent compressions. There was no prolonged compression. The video shows that clearly. There was no medical support for delayed mechanical asphyxiation, as Dr. Leckwith seems to think happened, and Dr. Singhania, and somehow Dr. Hugelin. Once the weight is lessened or taken off, he testified, and the person is still speaking, that means they've got enough air. They're breathing fine. The system will correct itself like that. Like that. He went over all the records. It didn't happen in this case. He's the only one who's patently honest. I can't say what caused his death. I can say what it wasn't. And Kelly Thomas was speaking, yelling, and he talked about how he backed up his opinion from the evidence. Every 2 seconds, rhythmic, yelling, screaming. That yells, you take in air, and to be yelling, you have to let out a lot of air, which is exhaling that CO2 we talked about. But then to be able to yell a second time, you have to take more air in. If you exhale everything, you got nothing left to speak again. That didn't happen in this case. The continuing myth of blunt force facial trauma causing death. And this is something else that we have to just at least deal with now, spend just a couple minutes on and get past. Dr. Vilk explained the mechanics. See, the prosecution asked how it could contribute, but they never explained these mechanics. Can you explain why you have that opinion as far as a blunt force trauma to the head not either causing death or being contributory? Sure, blunt force trauma to the facial portion, people get beat up all the time at the jail, and the ER will see them. Doesn't kill them. Lacerations are uncomfortable. You can get facial fractures. That in itself doesn't kill anybody. And then he goes through how it works. In facial trauma, the way that works, somebody has to have a bleed of the brain or swelling in their brain that forces the brain contents to go down the brain stem, which is the back of the head over here, which is where all the respiratory centers are. If it gets swollen, a big bleed in there, it starts pushing down. It can cause you to stop breathing or cardiac arrest. That didn't happen in this case. The CAT scan was actually normal, and Dr. Leckwith said it was unremarkable. There is no doubt there is no head trauma in this case that caused herniation. You would see it. So facial trauma itself, cuts and bruises and fractures, but that doesn't kill people. What tends to kill people from facial trauma is if something happens inside the brain, inside the head. The CAT scan being normal basically rules that out. It doesn't look pretty, but it was not a contributory factor. It wasn't part of the causation. It wasn't a substantial factor. Now, Sergeant Craig said he heard Kelly Thomas say, "I can't breathe." But he had no concern to tell him to get up. Why? Because he was still a threat. What does that mean? He wasn't just saying, "I can't breathe." He was still struggling, resisting. That wasn't somebody who was using all their energy to try to breathe. He was struggling, resisting. And at that point in time, and this we get into my client acting reasonably this entire time. He recalled, my client's the one who called for the medics. But when did that occur? That occurred when my client was leaning against Kelly Thomas's legs. When he heard Manny Ramos say there's blood everywhere, the first time they saw it after they rolled him over, right when he says that, you see in the video, we went through it with Mr. Wilson, my client got on his radio and called for medics. He realizes, okay, my back is to this, but somebody says there's blood everywhere, we'll call for medics. And also on that video, on the transcript, my client's the one who says, that guy over there, he's who you have to look at. Now, there was testimony from Dr. Lekua that cardiac arrest from overexertion can begin with the heart slowing down, leading to an arrhythmia, which would cause poor circulation. And if uncorrected, that poor circulation would lead to a low or a poor oxygen flow through the body. And that could lead to hypoxia if uncorrected. And that could lead to organ failure and cardiac arrest. Overexertion. And Dr. Hugelin concurred with that. Now, Dr. Budoff did not. Again, 3 doctors, 2 opinions. Dr. Budoff said, I agree with everything except the heart would speed up, not slow down. So you've got a trauma surgeon and a pathologist saying the heart would slow down. You've got a cardiologist saying the heart would speed up, but everything else applies. Again, they can't seem to agree. But the officer should know. They should foresee all this. And if he's fighting, he's struggling, he's resisting, he's not complying, and that's what occurs because of that, they're not responsible for that. Criminally responsible? Criminally negligent? A person acts with criminal negligence when the way he acts is so different from the way an ordinary careful person would act in the same situation, which means an ordinarily careful police officer, because that's the situation they're in, responding to a combative suspect, that his act amounts to a disregard for human life or indifference to the consequences of the act. Now, an ordinarily careful person would act in the same situation, like we just said, an officer with my client's training experience. The manual, Corporal Rubio, Sergeant Craig, his experience. Now, Corporal Rubio testified that he looked at this video, and my client's actions were consistent with his training, consistent with training. And that's what a reasonable person in this situation would rely on. Sergeant Craig had no problems either. Experience. Monitored 2 Code 3 requests for help. And according to Mr. Akakis, he'd expect my client arriving at the scene to think this is a resistive, fleeing suspect. He'd expect my client to want to jump in the fray and help. So that's reasonable. He sees he's actively fighting with the officers. He's not under control. And an officer, let's understand something, folks. We're about to get into the excessive force part of this case. Under control for an officer means he's handcuffed, he's patted down, he's 100% secured. Doesn't mean he's happy sitting on a curb. Unless he's on a curb, not resisting, not combative, going with the program. Under control means he does what I say when I say it. That's what under control means to an officer. It's not like we think of, you watch the movies and there's a fight and the good guy is fighting the bad guy and the bad guy drops his gun. The good guy says, oh, you dropped your gun? Here, pick it up. That's fair. That's not real life. Real life is I'm a cop, I'm a police officer, and like Mr. Wilson said, I have to have more force when it's coming at me, and not just more, so much more that I don't have to worry about getting control. That's how much more. It's not equal, because it's one thing just to fight somebody to being an equal. We talked about in the very beginning, police officers, they don't get paid to tie. I have to have so much more that I can stop him, control him, and secure him. That's it. That was far from happening when my client arrived. He tried to extricate. This is part of the experience of this case. No effect. Taser, drive stun, no effect. Darts, again, to incapacitate, no effect. He's going through his training, one by one. That's not somebody who's acting recklessly, with a disregard for human life. He's going through his training, what he's been taught, and what in his experience should work. But it doesn't. He tries a second drive stun because he's been trained, as Corporal Rubio testified on the taser, to close that circuit. This is somebody seeing what's happening, and he's making decisions each time. Okay, that doesn't work. I'll go to this level. And he's not going way up the ladder, folks. He's going just one step further to try to get him under control. That's somebody who's thinking. That's somebody who's assessing, who's not acting recklessly. And during this struggle, After the drive system doesn't work, after the wires are tangled, the suspect grabbed his weapon. That's a whole other arena. That puts into a different stratosphere. My client had to wrench the weapon away from the suspect. This is what's going on. This is part of the experience of a person in a similar situation. And even though he wrenches it away, he continues to try to grab it. And that's when my client, when nothing else worked and he's grabbing my weapon, he already grabbed it once, that's when he shifts and 2 strikes to the face. Controlled. If he was out of control and reckless, he'd keep going. 2 strikes, jabs. He's not going to drop his weapon and hit him with his fist because as he's been taught in his training from Rubio, from Craig, you don't do that. You never do that. So it's in his hand, but he has to stop him from grabbing it. He has to get his attention in such a way that he's not going to grab at it again. 2 strikes. That's it. He shifts, he hits twice, he stops, the hand stops grabbing. That's controlled. That's not reckless. Now, what did Mr. Wilson say about this? Mr. Rubio and Corporal Rubio and Sergeant Craig. Mr. Wilson, their expert, by the way, who they flew 3,000 miles to talk, their expert, that the overriding tactical principle, the overriding one, the only one that he says that comes first no matter what, officer safety. A police officer's job is very risky, and we already talked about this quote. They have a right to go home to their families too. But he also said that unrestrained hands are very dangerous to a police officer. And he admitted that when my client was there, those hands were unrestrained. It's the most dangerous situation an officer can face. That an unrestrained handcuffed hand could be used as a deadly weapon or a dangerous weapon. It's a dangerous weapon against an officer. And that hand of Kelly Thomas, that right hand was unrestrained and handcuffed. That a suspect's hands are the most important thing as a control. They're the ones that try to grab your weapons. His hands were not restrained and not under control. And now when he grabbed my client's taser, if you notice, nowhere on direct examination, nowhere on redirect, did they even come close to asking Mr. Wilson if he saw that taser grab. They keep leaving that out. That's the case, folks. That's why we're here. Because if he doesn't grab my client's taser, there's no reason to hit him in the face. He doesn't do it up until then. That's the crux of this issue. They don't ask him that. And he doesn't even talk about it. We have to walk him through the video and have him look at it in slow motion and and then he finally sees it. And then everything changes. Then he's testifying this way. Because weapon retention is very important for an officer to remain in control of the suspect and the situation. And Mr. Wilson said, if an officer loses possession of an impact weapon to a suspect, that would be a very dangerous situation for the officer. He said, Mr. Wilson, that a police officer should be entitled to rely upon his training officer in making decisions in rapidly evolving and stressful situations. Well, if the training officer says, you know what, you do not let them grab your weapon. Do not. You do not discard it. You don't put it away. You do not. You retain it at all costs. He should be allowed to rely on that, as an ordinarily careful person in a similar situation would do. And Corporal Rubio, we've talked about him. Now, the use of force training included, and this is where we get into the oral and the practical training as opposed to writing, included using a tool different than its classical use when necessary, and improvising. Because on the street, it's not like being in a classroom. It's not like being somewhere where it's nice and safe and comfortable. Things happen, they happen quick. You have to be able to improvise. He viewed the video. He saw all the different uses of the taser. And it was all consistent. And Mr. Rukakis admitted yesterday that my client's classical use of the taser was reasonable. So where are we getting at? He's trying his best. He's basing everything on his training. He's doing what a reasonably, ordinarily careful person would do in this same situation. But Corporal Rubio went one step further. It wasn't even practical for my client to discard his weapon. Now, we may think, why not just throw it away? If you get to that point he's trying to grab, just get rid of it. Well, first, we'll get to that more in the other charge. He doesn't have to. The law says you don't have to retreat. That's a form of retreating. He doesn't have to do that. As a police officer, he can pursue until the person is under control. But even more than that, it's not practical to do that at all. Because first of all, the darts are still in the person. The wires are attached to the darts. The wires are also attached to the cartridge, and that's on the taser. How far is it going to go, number one, if it's all wrapped up? Number two, it's giving the suspect access to it, or at least you've got that possibility. Number three, my client arrived on the scene. He had no idea what happened before he got there. He's got no idea if anybody's with this person, standing by, walking around. They could get that weapon. He said even the strikes to the face were consistent with training. Improvised tactics. Weapon retention. Never allow a suspect to gain that weapon. And this again goes to how, in this policy you have back there, this again goes to how an orderly and careful person would act in this situation. Now, you've heard a lot about ASP, and Mr. Rokakis had to admit that it's not the same as a taser, and they're just trying to make a comparison. But Corporal Rubio was very quick to distinguish between the true impact weapon, such as an ASP or a baton, and a taser. He really is the expert on it. He's the one who trains on these things. He knows the differences. They're not the same. And that's why he didn't consider the strikes to the face of Kelly Thomas to be even comparable with a taser to an ASP or baton. That's why they were consistent with training. So I think Kevin Craig, over 17 years' experience as a police officer. He also was a field training officer. He trained cops in the street. 3 code 3s are unheard of. He arrived, and Kelly Thomas, even after he was hit, was still out of control. Still fighting, still resisting. And he was asked, a question about, could a taser strike to the head or the face? Could that be deadly force? Yeah, it could. It could, depends on the circumstances. And not deadly force that it would cause death. Deadly force in that it could lead to death. Could. It didn't happen in this case. We saw the evidence of that. Again, that question was asked as a hypothetical. Could, may, if, not is. But he also said, if the suspect had grabbed Corporal Cisneros' taser almost out of his hand, that would present a very dangerous situation for the officers based on his and my client's training. And the same thing Corporal Rubio said. But he also went a step further. That it would actually be reasonable, based on their training, for my client to use that same weapon that's almost grabbed out of his hand, the same weapon the suspect's trying to get, as an impact weapon to stop him from getting it. Now, how would an ordinarily careful person act if that's his training, if that's his sergeant, that's his supervisor? Consistent with what he's been trained, consistent with the supervisor's opinions. Because officers are trained to avoid that from happening at all costs. And here's the policy. Reasonableness of the force used must be judged from the perspective of a reasonable officer on the scene at the time of the incident. Any interpretation of reasonableness must allow for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And that's important. That's not the trained under. That mirrors what we've been talking about an orderly, careful person in the same situation. That mirrors it, what we're talking about. You know, Mr. Wilson had 60 hours to look at this stuff. He had time during his testimony, overnight, during lunch hours. The prosecution may come tomorrow, this afternoon, and tell you that, well, here's another option he could have used. They haven't said one yet. It's been 2.5 years. This case went to a preliminary hearing. This case has been on trial. They had an expert. They had Corporal Rubio on the stand. They had Sergeant Craig on the stand. They had Mr. Wilson come from way back in Quantico. They had opening of their closing argument yesterday. Not once did they give you any alternative my client could have had besides that one. Not once. They say one now at the 25th, 27th hour. How credible is that? My client had a couple seconds, maybe 1 second to make that decision. They've had 2.5 years. They still can't tell you anything until we bring it up again. Split-second decisions. That's why we don't make this criminal. We don't second-guess that. He's acting consistent with his training. That's how an ordinary careful person would act. There's no criminal negligence here. We've already been through there's no causation. It wasn't a substantial factor. So we don't even get there. He's not even negligent. But it gets even more. There's an instruction, and it applies to both of these counts. What you heard testified to, I'm going to replace this instruction for a moment. Both Sergeant Craig and Captain Jones testified First Sergeant Craig, when he was asked why he felt comfortable about my client's strikes, was it based solely on the fact that the suspect could have had a weapon? No. He said, rather, Corporal Cicinelli had a reputation as a great decision maker. Not just as being okay or good, as a great decision maker. That means he had a background of always making good, responsible decisions. He had a reputation to be skilled at controlling scenes. And he had a reputation for taking the appropriate action. That means somebody who doesn't just do it once, that's part of their makeup. And you saw that because he went step by step through different tactics that he was trained on to try to control the scene. Step by step. Now, the instruction talks about that. You've heard character testimony that the defendant, Jay Cicinelli, is a person who makes good decisions and has not been seen to use excessive force. You may take that testimony into consideration, along with all of the other evidence, in deciding whether the people have proved that defendant Jay Cicinelli is guilty beyond a reasonable doubt. Evidence of the defendant's character for making good decisions and not using excessive force, which is Captain Jones, can by itself create a reasonable doubt. By itself means even with everything else going on, that's enough. The fact that this is who he is could be enough to create a reasonable doubt. And that makes sense, ladies and gentlemen, because you don't know him. You don't know any of us. You've got a snippet, a window. You've got the evidence in this case. That's it. That's all you're supposed to have. But somebody in his position, in Corporal Cicinelli's chair, they don't know me. They don't know that I'm not this reckless person they're portraying me as. I'm not this person that's just going to hit somebody for no reason they're portraying me as. That's not me. I've got a character for being the opposite. And if I have a character for being the opposite, then I didn't do what they said I did. Who would know that? People who worked with him, who worked alongside of him, who respected and admired him. That's who would know that. And that by itself is a reasonable doubt under the law. Captain Jones, the same thing. A captain. She supervised him as a lieutenant. Same thing. No complaints of excessive force. Good reputation. A good corporal, well respected. If a handy call is appropriately. He was not criminally negligent. The evidence clearly demonstrates that Corporal Cicinelli acted as an ordinary careful person would act in the same situation. That is consistent with his training, experience, and reputation. The government has not met its burden of proof. Obviously, folks, he's not guilty of involuntary manslaughter. Now, this is what we talked about. This is just one extra little piece of the puzzle to show this is somebody who's always assessing, always thinking, always trying to do what's right and trying to appropriately and effectively handle the situation. When he heard Officer Ramos say there's blood everywhere, that's when, we'll get to the next count, that's when he called for medics. We've been through count 2. He's not guilty. Not based on the evidence, not based on the law. Not at all. Count 3. Assault and battery by a peace officer. The myth of excessive force. Again, there's going to be more black ink. The octopus. Here is the instruction. We'll go through it. Now, here basically are the elements. To be charged, the people also allege that the commission of this crime with criminal negligence is one of the theories on which they base the charge of involuntary manslaughter. Now, we've been through that. He's not guilty of that. That's up there to show that this charge also could go towards that count. That count has not been proven. Now we're on count 3. Every public officer who, under the color of authority, without lawful necessity, assaults or beats any person is guilty of the crime of assault or battery by a public officer. And here are the elements. Now, the first element, that he's a public officer at the time, that's a given. We wouldn't be here on this count. The second, acting in the color of authority, yeah, he was responding to 2 Code 3s as a police officer. The third one, assaulted or beat a person, that's not been proven, and we'll get to that and why. And the fourth, he acted willfully, well, yeah, he did the act willfully. He shifted, he hit him to stop him from grabbing his weapon. And the fifth, they used more force than reasonably necessary to effect the arrest, prevent escape, or overcome resistance? No. That's not been proven either. Now, to prove that, they've been through it, they have to prove the people, the government, that he did the act, which he did, which are the strikes to the face. It was willful, yes, he did mean to hit him in the face to stop him from grabbing his weapon. He was aware of the fact to lead a reasonable person to believe that there would be force applied, because he meant to apply it. When he acted, he had the present ability to act, and he did. But they also have to disprove that he didn't act in self-defense. They have to disprove that. We don't have to prove it was self-defense. They have to disprove it. And there's 2 facets to this. There are 2. Because there's self-defense and weapon retention. But it also wasn't an assault. Now, here we get down again. And we'll go to the next part of that instruction. Because the elements here are, he was a police officer, acting as a police officer. Was there an assault of some kind, that touching, without legal necessity? Let's focus on the last 2. For the assault, the prosecution has to prove beyond a reasonable doubt that it was not self-defense. Here's self-defense. Self-defense is a defense to the crime of assault and battery by a public officer, violation of Penal Code Section 149. The defendant is not guilty of that crime if he used force against the other person in lawful self-defense or defense of another. Now, this is something that people have to disprove. The defendant acted in lawful self-defense, defense of another, if, 1, the defendant reasonably believed that he or someone else was in imminent danger of suffering bodily injury. 2, the defendant reasonably believed that the immediate use of force was necessary to defend against the danger. And 3, the defendant used no more force than was necessary to defend against the danger. Now, that's self-defense. And what we have here is we have circumstantial evidence at best to say that it was unnecessary. And what's the evidence? What's the evidence? The evidence is the bloody picture. That's what Mr. Rakakis argued to you. I mean, strip away everything. What he said, and actually this is not a quote, but it comes pretty close, is he puts the bloody picture up at the end of his argument. Remember we talked about the emotion, the black ink? And he said, is that the result of reasonable force? And that's all he said. That's not proof beyond a reasonable doubt. But you also have the rest of the evidence. And my client made statements. And those statements he made were on tape after this event occurred. And you've heard them a few different times. He talked about how at one point Kelly Thomas tried or grabbed this out of my hand, the taser. He says that. It's on tape. You've got those tapes. And all the evidence points to that if that occurs, he's got a right to self-defense. Because here's the rest of that instruction. Circumstances as they were known to and appeared to the defendant. That's my client, Corporal J. Cicinelli. What did he know? That this suspect, who has not been in control for 3 or 4 minutes, who keeps resisting, keeps fighting, grabbed my weapon. I almost lost it. And he keeps trying. what a reasonable person in a similar situation with similar knowledge would have believed. We've been through a lot of that in the last count. There's a lot of a comparison. If the defendant's beliefs were reasonable, the danger does not need to have actually existed. That means he doesn't have to wait until the person gets the taser. He doesn't have to wait until the person beats him with it. He doesn't have to wait for that. It's too late at that point. We don't put that on anybody in this society. Self-defense means if the threat is imminent, I don't have to wait till I get hurt. And if you're a police officer, you're trained to never let that happen, to never wait until the weapon's gone, to never wait until the suspect has the weapon. It's too late. That makes sense. Now, here's this part. Mr. Barnett spoke about this at length. If you find that Kelly Thomas threatened or harmed others in the past, you may consider that information in deciding whether the defendant's conduct and beliefs were reasonable. Now, there's a reason why that's in this case. It's not to smear Kelly Thomas. But you have to know everything. You have to have a real, complete, truthful picture. No one is asking you to find our clients not guilty because Kelly Thomas had a violent past or had outbursts of violence. But we'd be remiss if we didn't at least tell you that you have to consider that factors into the whole equation. Because you have to know, really know, who they were dealing with that night. This wasn't somebody who was timid, who was helpless. This was somebody who would not allow these officers to control him and be handcuffed. He was not scared for his life. He was scared of being arrested, if anything, at all. And he said that before it happened. He said, I don't want to go, in a challenging way. And he proved that because he was not willing to let them handcuff him. He's been arrested before, folks. He knows what it's like to get arrested. He knows what he's supposed to do. He can go with the program. He decided that night not to. He did. That's what that's there for. A defendant is not required to retreat. My client doesn't have to give up that weapon, doesn't have to discard it. We've talked about how impractical that is, and there's one more piece of that which we'll get to of why it's so impractical. He's entitled to stand his ground and defend himself, and if reasonably necessary, to pursue an assailant until the danger of bodily injury has passed. Now, that's just an ordinary person. Put that person in a similar situation as a police officer. My client's trained not just to pursue the assailant, the suspect, until the danger passes. He can't even do that. He's tasked with controlling that suspect, that assailant, that person trying to grab his weapon. He's not trained to say, okay, fine, you can run away, I'm safe. He can't let this guy run away. He can't let this guy get up. He has to control him. This is so even if safety could have been achieved by retreating. Even if the prosecution says, well, he could have gotten up off him if it was getting too much, which is ridiculous. But if they say that, he has no duty to. Not with a combative suspect trying to grab his weapon. The law says no. The people have the burden of proving beyond a reasonable doubt that the defendant did not act in lawful self-defense or defense of another. And they haven't met that burden. They haven't come close, not to his use of force, without legal necessity. This jury instruction talks about some of the things my client's working under. Any peace officer who has reasonable cause to believe that the person to be arrested has committed a public offense may use reasonable force to effect the arrest, prevent escape, or overcome resistance. Now look at that. That's not even the same as self-defense. So on the one hand, they have to prove it wasn't self-defense based on all these actions, based on the weapon grab, based on the danger. But even more than that, my client has a right to use force even if it's not self-defense, just to control him. That's what he's tasked with doing. He's a police officer. We give them that ability. The law says if he's doing that, and he's doing it reasonably, which would be based on his training, he's not guilty of a crime. That's why training evolves. That's why tactics evolve. That's why they come up with new tools. What's going to work better? What's going to be more effective at controlling suspects? This is an evolving thing. A peace officer who makes or attempts to make an arrest need not retreat or desist from his efforts by reason of resistance or threatened resistance of the person being arrested. Again, he doesn't have to retreat, doesn't have to discard the weapon, doesn't have to get up. We'll talk about why he couldn't. No such officer, nor shall such officer be deemed an aggressor or lose his right to self-defense by the use of reasonable force to effect the arrest, prevent escape, or overcome resistance. Talks about if he's performing his duties unlawfully, then of course, if he's unlawful, it's unreasonable force. But we don't have that here. And to try to put you in the mind of Kelly Thomas and to see the case with Kelly Thomas is wrong. Again, that's the black ink. That's trying to pander to emotion as opposed to reality, as opposed to what you've been charged with as a juror, what you've sworn to do. Now, the rest of this isn't as applicable to my client because when he shows up, the fight's already on. You're not going to tell somebody, by the way, you're under arrest when that person's not controlled and the fight's on. And even Mr. Akakis admitted that any reasonable officer would have jumped into that fray. He said that yesterday. But it gets more than that. They've talked at length about deadly force. This is what my client was trained under. This is why Corporal Rubio said that a taser blow to the face would not be deadly force in his mind. And he's the training officer, and he's the one who informs our clients of what they could reasonably expect or anticipate. While the use of a firearm is expressly considered deadly force, other force might, Rubio was talking about, also be considered deadly force if, again, another qualifying word, the officer reasonably anticipates and intends that the force applied will create a substantial likelihood of causing death or very serious injury. No evidence of that. My client anticipated this to be deadly force somehow, to cause death or serious injury. He doesn't stop hitting. His strikes were measured. They were controlled. They were there for one purpose: stop grabbing my weapon, and they worked. And when it worked, he stopped. That's it. He doesn't keep going. There may be an argument that, well, Sergeant Craig was showing up. He wasn't there yet. He was coming up to the scene, and my client was turned away from where Craig was coming from. Craig came from the right of that picture. My client was turned to his left because, remember, he doesn't have a left eye. He had turned himself to make those strikes. He doesn't see Craig coming. He turns, and there's a few seconds in between after those strikes, and then he kind of comes back in. He looks up. He says, "Help us. Help us." He's still not under control, but he's not grabbing the weapon anymore. The prosecution has to prove beyond a reasonable doubt, without legal necessity, means that my client used more force than necessary. Now, they haven't told you how much would be necessary. They haven't told you that. In 2.5 years, they come up with something now. You have to wonder where they came up with it. And if it took them 2.5 years to come up with it, and several closing arguments, how much time did he have? Really? And that's the circumstantial evidence. We've had it up all day. Now that's here. If the evidence leads to 2 reasonable interpretations and 1 points innocence, then my client's not guilty. End of story. And that's that one section. He was trying to overcome that resistance. He was actually defending himself in self-defense. That threat was imminent. That taser almost came out of his hand. And again, look at what we asked the different witnesses. We talked about at the very beginning of the argument. The manual and the section we just talked about, the use of force, is it foreseeable? Now, the manual talks about appearing necessary to effect control. Must allow for the fact that the police officer decision is a split-second decision in circumstances rapidly evolving. And the deadly force must anticipate and intend. That's what he's working under. That's why this was not an assault, it was self-defense. That's why this was not Dr. Lekwa said the facial injuries were not lethal. Dr. Vilk said they're not lethal. We don't die